All right, we've got this breaking news just coming into our newsroom right now.
Major Supreme Court ruling.
Major ruling involving the Second Amendment.
Most significant case regarding the Second Amendment in more than a decade.
The Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decisions.
It's a case that legal experts will be watching closely.
The Ninth Circuit upheld California's ban on magazines that hold more than 10 rounds,
saying setting a higher threshold in an emergency could mean life or death.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
Everybody has a right if they're a responsible adult.
That's unconstitutional. That puts a limit on the right to have a gun.
Something extraordinary just happened in federal court that could rewrite gun rights across America, and almost nobody noticed. A federal appeals panel didn't just strike down a magazine capacity ban. They demolished it so thoroughly that the state can't simply rewrite the law and try again. But what's really got legal experts buzzing isn't the court decision itself. It's what happened afterward when a Supreme Court justice decided to speak up instead of staying silent. That statement, just a few carefully chosen paragraphs, is now being analyzed word by word by constitutional scholars who believe it's a roadmap for what's coming next. Let's start with what makes this appeals court ruling fundamentally different from every other magazine ban case you've heard about. The court didn't issue a temporary hold or send it back for reconsideration. They issued a permanent injunction. Read that again. Permanent. Law enforcement in this state cannot arrest anyone, cannot prosecute anyone, cannot even investigate anyone for possessing standard capacity magazines. Ever. That door is closed, locked, and the court threw away the key. 3 appellate judges reviewed over 2,000 pages of evidence. They heard from 47 expert witnesses, constitutional scholars, historians who specialize in founding-era law, firearms experts, criminologists, even medical examiners. And here's what almost never happens in Second Amendment cases. All 3 judges agreed completely. Federal court statistics show unanimous decisions in gun rights cases occur less than 12% of the time. These are contentious issues where judges frequently split, but not here. The evidence was apparently so one-sided that even judges with different judicial philosophies reached the same conclusion. The state's entire argument rested on a simple premise. Restricting magazine capacity would reduce violence. Sounds reasonable, right? Except when the court examined their evidence, they found it so fundamentally flawed that they used words like speculative and contradicted by the record. We're not talking about a close call where judges disagreed on interpretation. The state's case collapsed under scrutiny so badly that the court felt compelled to make their injunction permanent, meaning the constitutional problem isn't something minor tweaks can fix. The whole approach violates fundamental rights. Now here's a number that puts this entire debate in perspective. 100 million. That's how many magazines holding more than 10 rounds currently exist in civilian hands across America. Not a typo. 100 million. If you handed one to every third person in the United States, including babies and children, you'd run out of people before you ran out of magazines. These aren't exotic accessories that gun enthusiasts special order from obscure manufacturers. They're standard factory equipment that comes in the box when someone buys a firearm legally at their local gun store. Manufacturing data revealed something the state desperately didn't want discussed. Between 1990 and 2023, American companies produced over 4.5 million magazines, exceeding 10 rounds every single year. The most popular handgun in America, the Glock 19, ships from the factory with a 15-round magazine. That's not a modification or an upgrade. That's how the firearm is designed to function.
The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
The Supreme Court has issued a ruling.
Glock just got by California. Yeah, I said it.
The right to keep and bear arms shall not be infringed.
It conflicts with the Second Amendment's right to bear arms.
This is a case that's been bounced around back and forth throughout the court system.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
The biggest handgun company on the planet just got told to sit down, shut up, and redesign 80% of their lineup.
That law cannot stand.
The court pointed out that restricting magazines to 10 rounds means banning the standard configuration of guns that account for over 60% of handgun sales nationwide. You're not talking about some fringe product. You're talking about criminalizing what tens of millions of Americans already legally own. But here's where the state's case completely fell apart, and this connects directly to why that Supreme Court justice felt compelled to make a statement. Under current Supreme Court precedent established in the Bruen decision, states defending gun restrictions must prove that similar laws existed during America's founding era. It's called the historical analog test. The state needed to find laws from colonial America or the early republic that restricted magazine capacity or ammunition feeding devices. They brought in professional historians who combed through colonial statutes, state laws from the 1700s and 1800s, territorial regulations, municipal ordinances, thousands upon thousands of historical documents spanning 150 years. And after all that research, they found exactly 0 laws limiting how many rounds a firearm could hold. 0. The closest they could offer was an 1878 Massachusetts law about storing more than 10 pounds of gunpowder in residential areas. The court correctly noted this had nothing whatsoever to do with limiting ammunition capacity in actual firearms. Under oath, the state's own expert historians admitted that magazine capacity restrictions are a 20th century invention. They simply didn't exist during the periods relevant to constitutional analysis. Making matters worse for the state, historical records showed that during the founding era, repeating firearms existed and were known to the framers. The Girandoni air rifle, for instance, held 20 to 22 rounds. No laws restricted its capacity. In fact, many states actually required citizens to maintain firearms with sufficient ammunition for militia service, which directly contradicts the entire premise of capacity limits having any historical foundation. The state's lead historian became so flustered during cross-examination that he admitted the gunpowder storage law wasn't even a particularly strong analog. Translation, we've got nothing. The appeals court absolutely eviscerated this attempt to use an irrelevant powder storage regulation as justification for magazine bans. Now let's talk about self-defense, because this is where the court heard testimony that genuinely changed how judges view this issue. FBI statistics show the average self-defense encounter involves about 2.7 shots fired. Okay, well, under 10 rounds, right? Except in 23% of defensive gun uses, the person faces multiple attackers. And here's the kicker, even trained law enforcement officers have accuracy rates of only 20 to 30% in high-stress encounters. They miss 7 out of every 10 shots. Regular citizens defending their homes aren't hitting the range twice a week like police officers. They're everyday people who might need multiple rounds to stop even a single determined attacker.
It's a brazen home invasion. 2 armed men burst into a house in Pasadena, Texas. 3 victims are ordered to the floor.
The court examined 127 documented self-defense cases where homeowners needed more than 10 rounds to stop attacks, including incidents where citizens faced 3 or more criminals simultaneously breaking into their homes. Reloading under stress takes 3 to 5 seconds on average. That might not sound like much, but medical examiners testified that attackers high on drugs or experiencing adrenaline surges may not stop even after being shot multiple times. Those 5 seconds spent fumbling with a magazine could be fatal. The state's own firearms instructor, brought in as an expert witness, admitted under oath that he would never want to face a home invasion threat with only 10 rounds available. One case involved a woman who fired 13 rounds defending herself and her children from 2 home invaders. Under the state's ban, she would have been forced to reload while criminals were actively attacking her family. The state tried presenting crime data to prove magazine bans reduce violence. The court tore it apart. One study counted any shooting with 4 or more victims as a mass shooting, but then excluded 68% of those incidents from final analysis because including them contradicted their desired conclusion. Another state-funded study claimed magazine bans reduced shooting deaths by 11%, but when defense experts reanalyzed the same data with proper statistical controls, they found no statistically significant effect whatsoever. States with magazine bans showed no measurable decrease in overall homicide rates compared to states without such restrictions when controlling for variables like population density. The state's own internal law enforcement reports found no correlation between magazine capacity and crime rates in the 5 years before and after similar bans elsewhere. The state's criminology expert admitted criminals rarely comply with magazine restrictions and easily obtain banned magazines through illegal channels or simply drive to neighboring states. Here's the truly damning evidence that exposed magazine bans as political theater rather than effective policy. When Connecticut enacted their magazine ban requiring registration, they estimated 2.4 million magazines would need to be registered. Only 38,000 actually were, a compliance rate of 1.6%. New York saw similar results with estimates suggesting less than 4% compliance statewide. These bans don't remove magazines from circulation. They turn millions of law-abiding citizens into technical criminals, while actual criminals ignore the law entirely. California spent over $24 million enforcing their magazine ban between 2016 and 2022, resulting in prosecutions in only 89 cases. 91% of those cases involved defendants already facing other serious criminal charges. Law enforcement agencies testified they lack resources to enforce magazine bans and that doing so would require unconstitutional door-to-door searches. Now we get to why that Supreme Court Justice's statement matters so much. The justice didn't just deny the state's emergency application. The timing was strategically calculated. Court watchers noted the justice waited 11 days to issue the denial, far longer than the typical 48 to 72 hours for emergency applications. During those 11 days, 3 other magazine ban cases in California, New Jersey, and Massachusetts reached critical junctures in circuit courts. By waiting and then issuing a statement rather than staying silent, the justice ensured all pending magazine ban cases would have this guidance before lower courts ruled. Legal scholars found 17 specific phrases in the statement directly quoting or paraphrasing Bruen's most restrictive language about historical analogs. The justice specifically used the phrase serious constitutional questions, language that appears in Supreme Court precedent only when the court believes lower courts have gotten the law wrong and need correction. Constitutional law professors note this type of statement typically precedes the court granting review in similar cases within 6 to 18 months. Writing separately, rather than letting the denial speak for itself, signals to lower courts that continued enforcement of magazine bans may result in reversals on appeal. This wasn't a casual comment. This was a warning shot across the bow of every state still trying to enforce these restrictions. The implications are staggering. Multiple circuit courts are now deciding magazine ban cases with this Supreme Court statement hanging over their proceedings like a sword. Lower court judges know that if they uphold magazine bans, there's a strong chance the Supreme Court takes up the case specifically to reverse them. That kind of pressure influences judicial decision-making in ways that are hard to overstate. We're watching constitutional law evolve in real time, and this justice's statement suggests the Supreme Court is preparing to settle the magazine ban question nationwide sooner rather than later. States that thought they could keep these restrictions in place indefinitely by tweaking language or adding new justifications just learned that strategy won't work. The constitutional defect is fundamental, and no amount of legislative wordsmithing will fix it. That's it for today, folks. See you in the next video.